Hello again, you Midas Mighty. Harry Littman of Talking Feds here with my reaction to today's oral argument in the Supreme Court in the 303 case. Let me set this up quickly. Many of you will recall that a few terms ago, there was a case called Masterpiece Bake Shop. It was out of Colorado. It concerned a baker who had religious objections to same-sex marriages and therefore did not want to use his artisan talent to do a cake for a same-sex wedding. There was a law, however, in Colorado that says businesses can't discriminate against different groups. One of them are gays and lesbians, and that would include same-sex marriages, and that went to the court. The court essentially held for the baker, but on procedural grounds that are pretty narrow. Now the case returns in very similar form. We have a website designer. She does websites for weddings. They're nothing expressly religious or, for that matter, pro-gay couples. They're simply Bob and Jane or Bob and Michael are getting married, some gauzy pictures, and here are the events, etc. However, the same thing happened to her, or she thinks will happen. An interesting part of the case is it's all kind of in advance of the real rubber hitting the road. But the idea is she doesn't want to have to do a website for a same-sex marriage. Why not? Because she believes that would be the equivalent of being compelled to endorse same-sex marriages, and she doesn't believe in them. She has deeply held religious beliefs against them, in fact. So it's the same Colorado law. It says for businesses you have to be open and can't discriminate against a number of different groups: race, religion, and sexual orientation. So the case comes to the Supreme Court now, and the argument was long, over 2 hours, and very interesting, a sort of back and forth between justices and lawyers who see this as the state kind of compelling someone to endorse a same-sex marriage versus what the United States, that was in the case on behalf of Colorado, and the justices like Justice Kagan or Justice Jackson would say, no, this isn't forced speech. This is just, doing the basic act and not being able to throw it out or decline to do it just because of your discrimination based on religious preferences against gays and lesbians. This is what you could call a generalized law, and the Colorado law, and it's not forcing anyone to say anything, and therefore to refuse to serve a gay and lesbian couple would be to engage in discrimination against this law. Now, there are a lot of members of the Supreme Court. They took the case after all, and you have to imagine they are looking once again to sort of redraw the line that is between free exercise of religion and equal protection, where religious people don't believe in it. And in the context of that kind of ongoing cultural and legal tension, the arguments today were pretty interesting. So Justice Alito, who obviously is strongly for the ability of the religious website designer to rebuff, to not have to do business with a gay and lesbian couple. First, he was at great pains to say, stop analogizing the discrimination here to racial discrimination, which everyone's against. And you could see him sort of bristling at the notion that because he takes this kind of claim seriously, it means he must be a racist. Of course, nobody says that. What they say is, look, we have an anti-discrimination principle. Here's how it's applied against race in the past. So how can you apply it differently? And an even stronger analogy that I think will be central to the case, however the court decides it, is the military, because the military, remember, had the don't ask, don't tell policy that was in effect discrimination against gays and lesbians. And many law schools found that policy to be anathema. But the U.S. had a law passed that said, law schools, you have to be open to all comers who want to recruit, including the military. Law schools wanted to say, we don't want to have the military on campus. And the government said, too bad. We're not asking you to endorse their discriminatory views, but we are requiring you to keep be open to them in the same way you are to a law firm or the Department of Justice or the like. And that law was upheld. So what's the difference, you might ask, as did several of the justices, between a law that forces schools who don't believe in the government policy of, or the military policy that discriminated against gays and lesbians, of letting them come in on the same basis as everyone else, and a law, in this case Colorado's, that said businesses don't have to, just like the law schools don't have to say, rah, rah, we love discrimination. They did have to treat them equally. What about a law that says you also have to, you're a business, you can't just turn away gays and lesbians because you don't agree with the policy? How will the conservative 5 or 6, which obviously took the case to try to rule for the free exercise, how will they deal with that? You could see at the end a little strategic move by Justice Kagan that pointing out that the record here wasn't really developed at all. No one has yet. The hammer from Colorado hasn't come down on this woman who wants to be able to avoid doing website design services for same-sex couples. Her lawyer did say in the oral argument it's a terrible transgression and it's government forcing her basically to speak up in favor of same-sex marriage, which she doesn't believe in. The possible way out that Kagan seemed to be exploring is a remand to a lower court because so many of the facts weren't developed. Again, that would just be to dodge the same bullet that was dodged in the Masterpiece wedding cake case, and keep the Supreme Court from saying definitively you cannot do this kind of law, Colorado, because it infringes on free exercise rights. The sort of proposition that would have been not even thought of 10 years ago, but is now very much on the table with this new conservative court. So there you have it. Meidas Mighty. Watch for that case, the 303 creative case that's just been heard. And in a few days, the Moore versus Harper independent state legislature doctrine case, a big week coming up in the U.S. Supreme Court. And when other important developments there or elsewhere come around, you can bet I'll be here to give you my reaction. Also, want to remind you that Talking Fez has its own YouTube channel where I put a lot of quicker and longer discussions on important developments of the day. But when big ones come around, I'm here to give you my reaction, and I'll see you soon because lots is happening. And until then, talk to you later.
MeidasTouch is unapologetically pro-democracy, and look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs, It Wasn't Rigged, You're Just a Loser, at store.meidastouch.com. That's store.meidastouch.com.